Good afternoon. Welcome to Division 2 of the Colorado Court of Appeals. We have two cases on our docket this afternoon, and I see counsel are seated at the table in People versus Fair. And also the second case we have is Centennial Owners Association versus Aspen-Pitkin County Housing Authority et al. Are the counsel for that case here? Are they here? Yes. Are they here, please? Yes, Your Honor. Thank you. When you came in, you should have received some written oral argument instructions from the bailiff. Did you receive those instructions? You don't have to stand up. You're good. Yes. Okay, yeah, okay. You're good. Do you have any questions about those instructions? No? No questions? Okay. I would remind you that our oral arguments are being live streamed. They're also being video recorded. They'll be available on the website. Let's be careful about sensitive or confidential information. Please do not give the names of, say, sex assault victims or minors, things like that. When you come to the podium, give us your name and registration number. And everyone in the audience, please turn off your pagers or cell phones so as not to obstruct the oral arguments in this case. I think with that, we can begin.
Good afternoon. May it please the court. My name is Tara Yorfall, registration number 46193. I represent the defendant appellant, Craig Fair. Ms. Hoops made a mistake when she had recommended that Mr. Fair could avoid prison by taking an indeterminate probationary offer. Her advice was deficient, that the better offer was the indeterminate probationary offer rather than the 15-year determinate or taking the chances at trial. Mr. Fair does not dispute that she accurately advised, as well as co-counsel in the court, on the direct consequences of indeterminate and determinate sentences, and even some more of the nuances. The issue before this court and the district court was her affirmative misadvice that Mr. Fair could avoid prison by taking an indeterminate sentence, albeit probation, despite him being adamant he was innocent.
I thought she had a little bit more to her advice. I thought her advice was also, you can avoid prison, but you've got to take responsibility. If you stay in denial, there's a good chance you'll be revoked and you'll have to go to prison. I thought her advice encompassed that as well, counsel. Yes,
Your Honor, and Mr. Fair is not disputing that he was advised of the dangers of an indeterminate sentence per se, that you needed to admit to the offense. The problem was, as defense counsel also testified, Mr. Fair was not hearing her advice on indeterminate sentencing. And we have to look at the facts, which I believe are completely undisputed by the parties in this case, specifically that Mr. Fair was credible when he testified. He didn't understand until later really the consequences of indeterminate. And so while Ms. Hoops attempted to explain these things to him, she admitted he was not hearing her. We have to take this in the context that Mr. Fair was suffering from serious medical conditions at this time. He was in a high state of anxiety, and he was adamant he was innocent.
Counsel, I think her testimony was that he did understand. He's a smart man, but he was afraid of going to jail.
Well, there was, and I think that's part of the analysis, that he had this incredible fear of going to prison, and that's where the deficient performance comes in, is instead of telling him that the only way to avoid prison was to win at trial, she gave him the advice he wanted to hear, that you take this probationary sentence and you can avoid prison.
Ms. Yorfalt, pardon me. My understanding of the record is that his family members were also present during every one of these hearings and during these conversations, and that there were several family meetings around that very issue, and that in no uncertain terms the priority was to keep him out of prison. And so doesn't that seem to reflect that there was an appreciation and understanding of the potential risk of trial versus entering a plea and having the ability to, within his means, just to remain out of custody.
Well, and I think we have to really look at Ms. Fair's testimony, Mr. Fair's sister, about those conversations.
Ms. Fair, the sister who was a 31-year police department veteran.
Yes,
Yes, okay.
that's correct. The court found that she testified credibly that there was no conversation with the family who was involved in this process about indeterminate sentencing. And I think that's very clear and consistent with Ms. Hoop's testimony that he's not hearing the indeterminate. He's not weighing these decisions. And under Carmichael, he is unable to evaluate the advantages and disadvantages of this plea when she's recommending, and as the court says on page 6 of its order, which is the better sentence? Well, if you want to avoid prison, then you should take this probationary officer, because that's the only thing that will guarantee that you can stay out of prison. And as Mr. Becker and Mr. Benarski both testified to, that was just woefully inadequate, because the only, as Mr. Becker put it, light at the end of the tunnel would be time in prison under determinate, or as Mr. Benarski said, winning at trial.
Counsel, when Ms. Hoops testifies, he didn't want to spend a day in jail. He was afraid of going to jail. And she tells him that this is the only option that gives you a chance of not spending a day in jail, but there are risks. What else is she supposed to do?
Well, I think there needs to be adequate advice that you cannot recommend. It is misaffirmative advice that when you're talking about, because the question, and look at page, I believe, 64 of the transcripts in her testimony, when the question is, well, what did you advise about which offer was better? She said, well, because of his concerns about prison, I said, probation. And I get that it's more nuanced. But Mr. Fair, in his state of anxiety, where he's not listening to the nuances of everything, is relying on that misaffirmative advice that, yes, you can do this through probation. And at the time, right, in 15 years, only 2 individuals had ever done that, right? And Mr. Fair was not going to be a third individual. And for a defense attorney to say, well,
Counsel, how do we know that? I mean, in the same way that we don't know whether he would be successful or not, we don't know if he would have been successful at trial or not. Is that fair to say?
well, right, and I think that's a question, for prejudice on the weight of the evidence, and we can get that into a little bit. But whether or not he would have been successful, I mean, the chances when someone's adamant that they're innocent, it's impossible.
So that's a good point you bring up. He testified, Mr. Fair did, that he would not have taken the offer because I'm an innocent man. There was no way he was going to take an offer, so he would have gone to trial. But he did then go to probation, and he was successfully placed on probation. And the first question they ask on this kind of a sentencing is for them to acknowledge and take responsibility and have accountability, which he was able to do. It wasn't until 10 months later that he kind of denied his guilt.
Well, and so the question is whether there was a possibility of him being successful. And I think we have to rely on what was the prevailing norms of practice at that time and what advice provided. And I think you can find that by both Mr. Becker and Mr. Bernarski's testimony, that in a case where you have a client that's adamant he's innocent, that you have an evaluation that's done and he's denying defense. And even after the plea, when he's supposed to be taking responsibility, and he's still denying defense, that the recommendation that he could possibly be successful on probation was beyond standards.
Counsel, wasn't there a letter in the record indicating that after his plea, and he decides not to withdraw his guilty plea, he then goes to sex offender treatment and for a time at least admits responsibility, but only later changes his mind and denies responsibility?
Yeah, and I caution the court to rely on that. I would think under the standard of review that we should be reviewing the facts that the district court relied on to deny relief. And I believe the context of what happened afterwards in probation were only limited in the court's ruling. She found specifically that Mr. Fair was adequately advised of indeterminate sentencing by the court and possibly in probation. There were no factual findings at the hearing on what happened in treatment, and that was not part of the court's analysis. And although this court's analysis is reviewed de novo for the legal application of the facts, I don't think we have those facts as part of the court's analysis.
Weren't they in the second fair opinion? Wasn't that one also recited in the second fair decision by a division of this court?
Right, and I think we're at a very different stage, and I think that's important to bring up, right? Because we have some facts about, the indeterminate sentencing that were given in those opinions, and I would argue to this court that those facts cannot be relied on because those facts were based on a petition without an evidentiary hearing and a different standard of review where the court is reviewing everything de novo, whereas after the evidentiary hearing, claims change, right? I bring up Martinez Sanchez's case where it was discovered at the hearing the client couldn't read. And so I think it's really this court's job to rely on facts that were analyzed by the district court and what were provided and relied on by the evidentiary hearing, and then do a de novo review on whether those facts apply, were applied correctly to the Strickland test.
Can I ask a couple of questions?
Of course, Your Honor.
You started out by saying he did not understand. Did he tell his attorney he didn't understand?
Well, he did not, and I don't know if he realized.
How is his counsel supposed to know he doesn't understand?
Right, and I don't think that issue is really before us in this case because
Well, that's your argument, isn't it, that he didn't understand?
Right, but we have on the record that Ms. Hoops had some concerns. She debated competency. We don't know more than that because she moved on from that. But also she said, when I was talking about indeterminate sentencing, he was not listening. And we have a credibility finding from the district court that Ms. Fair and Mr. Fair's testimony that they didn't understand and really process these things and weigh the advantages until after his probation was revoked.
Okay, my second question is, as Judge Daly points out, he had the opportunity to withdraw his plea, and he chose not to. Do you have any indication in the record why he didn't?
Well, we have no indication that counsel advised him or provided any advice. You mean after the PSI?
No, that's not correct. Well, counsel, you may be right, I may be wrong. But as I recall, Ms. Hoops testified that after the PSI said that he's still denying, Ms. Hoops advised him he could withdraw his guilty plea.
Right, but there was no recommendation. There was no further urging. I don't disagree with your assessment. If there are no remaining questions, I would like to reserve my remaining time for rebuttal.
Thank you, counsel.
Thank you.
Good afternoon. May it please the court. William Kozlowski, registration number 37824 on behalf of the people. I guess I'll just start with Ms. Hoop's testimony that just refutes the defendant's claim. She testified that this was a dangerous plea if he wanted to take it, because if he maintained his innocence, he would get revoked and be sent to prison. And she told him about that. I spoke about it. He was afraid of going to prison. And the quote of, he wasn't listening, I read that as he wasn't heeding, I don't think he was appreciating the seriousness of her advice because he didn't want to go to prison, not that he didn't understand what she was saying. And that he was afraid to spend even one day in jail. So he decided to take the plea.
Does the record reflect, as counsel suggested, that the advice was that the sex offender probation was the better offer?
No, I don't think that's in the record. The record is, what advice did you give to him regarding that plea? And she testified his main concern was not going to prison, and if that's your main concern, the only option you have that will guarantee that the day after, or the day of sentencing, is this offer.
What happens to a person who sincerely believes they're innocent and they're trying to assess some fairly tough options, and one of the options is they're caught in this loop about sex offender treatment? You can't progress unless you admit your responsibility, and yet you've got a person who thinks that they shouldn't be responsible. Is there a way out of that loop for that person?
I guess I would say that the operative question is whether they understand that that is what's going to happen. And it's undisputed from the record that he was told by both his attorneys and at the Providency hearing that if he didn't admit, he would be revoked. So while that may be a tough choice, the only legal issue is whether he understood that that was the consequence, and there's nothing in the record to say otherwise. I mean, this is a case where he didn't have any good options, and it seems he wanted a good option, but that just wasn't reality. Everyone was if he got convicted at trial, which Ms. Hoop says was a fair chance he would get prison. The other offer was a determinate prison sentence that was 15 years. Ms. Hoops testified that they were concerned that that wasn't any different because he might die in prison because he'd have to do the full 15 because it was a prison sentence. Probation, the other option was probation. He was repeatedly told that he had to admit. The claims against Ms. Hoops in the previous appeal were denied because the record refuted his claims that he didn't understand sex offender treatment. So we're standing here years later talking about sex offender treatment again when a previous division concluded that those claims were refuted by the record without even a hearing. I mean, this case was remanded for a hearing on an offer that Mr. Becker supposedly gave him bad advice about. It was undisputed at the hearing that that offer never existed and the determinate offer never even existed while Mr. Becker was representing him.
Yeah, and no one complained about the possibility that the trial court or the hearing concerned matters beyond the remand. There was no complaint in the trial court, and as I read just one small part of the answer brief suggesting one issue might be off limits as far as beyond the remand.
No, I'm not making any argument that you shouldn't address that.
Okay.
I'm just saying how we've shifted here.
Counsel, you pointed out that there were two less than ideal options. And there was reference in the record about the state of his anxiety and his health. And given that there was this ongoing concern about his anxiety, his health, his ability to process this information, the lesser of two pretty dire options, and family being available and the family testifying that there was never any conversation about this, how do you believe the responsibility shifted, if at all, for counsel to ensure that this information was being conveyed and understood, being heard in a sense of process, not just heard like I can hear you, but understand and process?
I guess my answer is Ms. Hoops testified to that. You stated before that you said you weren't concerned, however, that he was understanding. Answer: I did think he understood me, yes. No, he's a grown, intelligent man. So it's certainly counsel's responsibility to ensure that their advice is understood. And both of these attorneys testified that under their impression that the defendant was understanding. And I have no doubt that the defendant was under anxiety. He was facing an indeterminate sentence. But Mr. Becker and Ms. Hoops testified that all of their clients are under anxiety, and both of them testified that he understood. And there is nothing in the record that they should have known he didn't understand, if that was in fact the case. If there are any other questions? Sure.
I do have a question. Was the family there at all meetings between Ms. Hoops and Mr. Fair?
I don't,
Was she there at a couple of those meetings?
no, I don't think, my short answer is no, I don't think so. The trial court's findings as to the sister's testimony was that she got all her information through the defendant, and so I don't think she was at the meetings. And that, I mean, kind of part of this is obvious. This is a sensitive subject where it's well and good to say now you should have brought in the family, but this is between the attorney and the client, where if you bring in the family, you're getting into murky waters on whether it's his decision or someone else's decision. But the record reflects that the defendant was told about all his options, that he understood all his options, and he made the choice he did. Is there no other questions? Thank you, Your Honors, for your time.
Yeah, I'm sorry. Go right ahead, counsel.
Thank you. I think there's a huge difference between defense counsel's obligation to make a defendant understand and provide meaningful advice that will help the defendant weigh the advantages and disadvantages of the plea, right? We have that in Birdsong, Carmichael, Hill, which states that the decision has to help him make a voluntary decision, and he could weigh these different things. And what we see is this just did not happen in Mr. Fair's case.
Can I ask you a question, counsel? Wasn't there evidence in the record that from both the expert, the legal expert, as well as from Ms. Hoops, says, I don't, or maybe Mr. Becker, I don't tell them which offer to take. I just advise them about the offers.
Yes, and I think that's the issue in this case is, and I'm gonna actually get the opinion from the district court, was that there was some misaffirmative advice. The question was, and I don't have the transcript before me, but the court can go back and review that on around page 65. The summary from the district court is, when asked during the hearing whether she provided Mr. Fair any advice or recommendation about which offer was better, Ms. Hoops testified that if he wanted to guarantee being in the community, there was only one offer that provided for that, which was the offer that called for a stipulation to probation. She further warned about the dangers of probation, ... And so here's the real issue, is that when he's lost in this world and trying to figure out what to do, he's not listening to the serious consequences. Instead, he's relying on his defense attorney. And, you know, he was allowed to rely on her in that recommendation she made. And at the end of that day, that recommendation is all he heard in his head. He went back to his family and said, I can avoid going to prison. This will keep me out of prison. I'm going to take this offer.
But let me ask you, counsel, to what extent does, you know, a person's listening or, you know, not so much understanding or ability to understand, but listening, oh, I listened to this part of my counsel's recommendations or advice, but not the other, so it must be my counsel's fault. To what extent is there a responsibility when the counsel is trying to advise for the recipient of the advice to try to listen, to try to understand, or to signal, I'm not understanding, or I'm not listening, I'm not listening to you anymore?
Right, and I've had this issue a number of times, and you know, the ABA's or our rules of professional conduct say when there's a client with a diminished capacity, it's defense counsel's obligation to make sure that he's in that same position where he can adequately weigh that. So that falls on defense counsel. Now, obviously, defense counsel has to be alerted to this, and I believe was in this case.
And it's a diminished capacity because the individual is anxious about going to prison, anxious about health concerns. Is that totally atypical?
Oh, absolutely not. But I mean, it's the same obligation no matter. It's the burden on the defense attorney to make sure that advice is being understood, and especially when they have notice of it. If there are no further questions, I would ask this court to reverse the order denying post-conviction for relief and set for a trial. Thank you.
Thank you, counsel, for your arguments in the case and for your answers to the questions that we put to you. Thank you. Our case will stand submitted. An opinion will issue in due course. We can now hear the case of Centennial owner versus Aspen, Pitkin County. Please.
Good afternoon. May it please the court. My name is Melanie Brooks, registration number 45322, and I represent the Centennial Homeowners Association. I'll refer to my client as the HOA. First, I'd like to discuss how Colorado's housing statutes apply in this case, and then second, I'd like to discuss why the CGIA doesn't bar the action. Now, the General Assembly authorized the creation of multi-jurisdictional housing authorities for the express and limited purpose of providing affordable housing, but it didn't intend to hold them accountable for fulfilling that purpose. That's the determination the district court made below, and the Housing Authority now asks this court to affirm. Now, this determination is premised on the absence of the term duty from the multi-jurisdictional housing statute. Because that statute doesn't set forth express duties, the reasoning goes, the powers it confers come without obligations. Now, that can't be true. Government entities are generally tasked with exercising their powers to promote the public's health, safety, and welfare. And here, the multi-jurisdictional housing statute specifically makes clear the powers it confers must be exercised toward an even more narrow end, to provide affordable housing. So the question before this court isn't whether the statute imposes any duty on the Housing Authority in this case, but rather, what are the parameters of the duty to provide affordable housing, and how do those parameters impact its obligations with respect to the Centennial?
The language of the statute is may.
Yes,
Is that
Your Honor.
correct?
That's correct, Your Honor.
How does that impose a duty?
Well, Your Honor, polities are not obliged to form a multi-jurisdictional housing authority, but when they do, the powers that any authorizing statute confers certainly aren't unlimited. And I would submit to Your Honor that whatever is enumerated in the statute implies the exclusion of other things. So because the statute says these entities may form multi-jurisdictional housing authorities and they may use them to provide affordable housing, I suggest that this indicates they may not use these authorities for any other purpose.
Can I ask you a different question? And this is sort of a background question. I understand that these units were built about 30 years ago.
They were built in the early 80s. Yes, so
And
it's about 30 years
I
ago.
assume that the units were all built before they were sold. Is that correct?
Yes, Your Honor, they were built by a private developer and then sold.
Has there been an action against the private developer?
Not that I'm aware of, Your Honor.
Thank you.
Now, the phrase provide affordable housing turns on the individual meanings of the words provide and affordable in the context of the statute. First, I'll discuss the term affordable. Now, the General Assembly has found the free market can produce affordably priced housing, but that housing tends to be unsafe and unsanitary slums. So the legislature authorized the creation of government housing authorities to address that problem. So when we're talking about government-driven affordable housing, we're necessarily talking about housing that's not only financially accessible to low-income people, but is also safe and sanitary. So
That's not in the multi-jurisdictional statute, is it?
That's not in the multi-jurisdictional statute. I'm referencing the General Assembly's findings and the legislative purpose of the city and county housing statutes.
Okay, and it'll be interesting to see how they get incorporated in the multi-jurisdictional statute. But even if there was, a duty to provide, why is a duty to provide more than a beginning place, more than, why does it encompass a duty to repair or maintain?
Certainly. Now, when we're talking about the term provision specifically, let's take a hypothetical. Suppose that a housing authority, in other words, build safe and sanitary housing, sell it, as you suggest, a one-time deal, and then walk away. Well, if a housing authority did that, buyers could then turn around and sell the property at market price. That's the practical equivalent of simply handing people money. So in that instance, the government isn't actually impacting the housing market, it's simply affecting an income problem. So I think the term provide necessarily has to indicate some sort of sustainable condition. Now, that combined with the term affordable suggests that housing authorities have a duty to provide sustainably safe, sustainably affordable, and sustainably sanitary housing.
Can I go back to my earlier question? If these were built 30 years ago, when did these defects show up?
Well, Your Honor, back in 2009, the first study was done as to the nature and extent of the defects. Subsequent studies have been done, but it wasn't until 2015 that the city actually sat down and determined what it was going to do about these problems. And
Okay, so that's almost 35 years.
that's true, Your Honor.
So how was how was the housing authority supposed to know there's defects that are going to show up 35 years later?
I'm not sure that it was supposed to know. I think that this is, I think everyone would agree this is an unfortunate factual development. But the problem here is that the housing authority designed the economy that Centennial exists in. They've set up parameters that currently prevent the housing from being repaired. I'd point the court to the deed restrictions, and this relates to the housing authority's private ownership argument. So the housing authority is arguing that it has no duty to repair Centennial specifically because the units are privately owned. But that term is very misleading here because the financial implications of owning a Centennial unit are very different from those that typically attend property ownership. And that's because of the deed restrictions. So the deed restrictions as a fundamental threshold to ownership state that you have to have a low income and relatively limited assets. Second, they also impose a cap on the resale price of any unit. And third, they cap the amount of value capital improvements can add to units. So basically what you end up with is a situation where the residents can't afford to pay retail price for the repairs that are necessary right now, but they also can't leverage their units as security and access private financing to make the repairs necessary. So we've got this.
Which theory are you arguing under? You had a mandamus action, you had a rescission action, you had a contract action. Which action are you following under?
I suggest that to meet its statutory obligation of restoring Centennial to a safe and sanitary condition, the Housing Authority really only has a few viable options. And that's why we're proposing it can either make or finance the repairs pursuant to the mandamus or declaratory judgment claims, or alternatively, if it can't raise the money to do so, it can rescind the deed restrictions so that private financing can step in and resolve the problems.
Okay, now, if you're arguing rescission, the district court upheld that. It's not entirely clear to me what you're seeking in rescission.
For rescission, Your Honor, I hope I'm speaking to your question. For rescission, what we're seeking is canceling the deed restrictions effectively as they apply to the units. Because again, the deed restrictions cap on capital improvements and their cap on the resale price is currently preventing the owners from harnessing the power of private financing.
Are those the two restrictions that you're seeking rescission of?
Yes, they are, Your Honor. Although to be honest, I can't speak to exactly the practical parameters of how much of the deed restrictions should be rescinded, but certainly those two provisions should be. And just to clarify my last comment, Your Honor, there are a number of other contingencies that necessarily depend on those two provisions in the deed restrictions. And what I mean by that is that if you rescind the resale price, then necessarily that will open up the opportunities for other people to come in and buy the units, which currently those opportunities are quite limited. So effectively, I think if you eliminate those two provisions, you've really basically canceled the deed restrictions. I'd like to turn now to the CGIA. Now, the question here is whether the HOA's public policy claim could lie in tort. The Housing Authority argues the HOA's injury arises out of tortious conduct, specifically the Housing Authority's concealment of construction defects from Centennial residents. So according to the Housing Authority's reasoning, this case is basically the Robinson case all over again. It's not. In Robinson, the lottery sold the plaintiff a ticket after all the prizes had been claimed. Now, the plaintiff alleged she would not have bought her ticket had she known the prizes were gone. Although she brought a breach of contract claim, the court found the injury giving rise to that claim would not have occurred but for the lottery's tortious concealment. And so accordingly, the CGIA barred her claim. Now, that's very different from this case. Here, the HOA's injury has nothing to do with concealment. Injury by concealment presumes Centennial unit owners would not have bought their units had they known about the construction defects. The complaint makes no such allegation, and the court cannot presume that that would have been the case. Now, the injury here is that Centennial's owners are living in deteriorating conditions that they can't get out of.
Is that somewhat similar to what used to be known as the warranty of habitability? Is that like the implied warranty of habitability, which used to be a contract-type remedy?
Are you referencing the safety and sanitation standards? So here, the safety and sanitation standards governing affordable housing within the state of Colorado depend on the local polities.
But
Code.
what I'm saying is your claim akin to basically a breach of the warranty of habitability?
No, I don't think so, Your Honor.
Okay.
Now, the cause of action for the HOA accrued not when the HOA discovered concealed construction defects, but rather when the city manager determined two things. First, that no public funds would be allocated to repairing Centennial, and second, that all necessary repairs would be subject to the recovery limitations for capital improvements. If there are no further questions from the bench at this time, I'd like to reserve my remaining time for rebuttal.
Well, I do have a question. You're stating that defendants have a duty. Where does this duty come from? It comes from the statutes, I think I hear you saying, right?
That's correct, Your Honor. It comes from a harmonious reading of the multi-jurisdictional statute along with the city and county housing statutes.
And what kind of remedy are you seeking?
We are seeking financing of the repairs at Centennial by the city, the county, or APCHA, the Housing Authority. Or alternatively, if that can't be done, we're asking for rescission of the deed restrictions.
So at least to a certain extent, you're claiming an injury in loss of money, right?
No, Your Honor, I don't think that's what we're
Or
claiming.
compensation for your lost money.
No, that's not what we're claiming. The Housing Authority has already spent over $900,000 making repairs. None of our remaining claims request any of that money back. We're still paying, our residents are still paying a somewhat high monthly fee for the HOA. We're paying over $600 per month right now. We're not requesting that back. This is not compensatory relief. The relief we are seeking is simply the ability to move forth and live in affordable and sanitary housing, and we currently just don't have that. All right, and I'll save my last 2 minutes for rebuttal.
Good afternoon, Your Honors. Josh Marks, registration number 16953, on behalf of the Aspen-Pitkin County Housing Authority and the City of Aspen. I'll refer to the Housing Authority as APCHA, which is its acronym, or Housing Authority, just to keep my words down. Laura Maker for Pitkin County is also with me at council table, but I'm speaking on behalf of all the appellees for purposes of this argument. Justice Marcus, you had a great question about what the nature of the injury is here, and it's property damage. They want the appellees to, they call it, they ask for an order from the court or a declaration declaring that the housing authority and the defendants, actually plurally, have a duty to fund repairs. But I mean, that's just semantics, really. What they want is money to help repair their property damage.
And what tort is that? That it looks like to you?
It looks like almost a fraudulent misrepresentation / negligent claim, because
By the housing
By-
authority?
by- Yeah, it has to be by the housing authority. It can't be by the entities, the public entities, because
No,
the
no.
public entities here don't.
Okay, counsel, excuse me. I'm going to ask a question.
Okay.
Thank you. You know, is it fraud by the public entities, or is it the fraudulent concealment by the builders that they're saying it was the result of?
Well, they're saying that, in their complaint, they have said that the public entities knew of these construction defects because these public entities were involved in the inspection process as they were built. And in one of the paragraphs, they say, you know, the housing authority finally learned what the defendants knew all along, which was these construction problems, these construction defects. It's right in their complaint, in their own words. So it looks to me like that's part of it, is you know, kind of a misconcealment claim, misrepresentation claim. Part of it is they're claiming, at least as to the housing authority, that the housing authority, since it manages the program, doesn't own the properties, it helps, you know, bring qualified purchasers in to buy these things and helps close these things, is aware of these construction defects and is allowing people into the system, into the affordable housing system, and getting them involved in these units. So in that sense, it's almost like also a fraudulent concealment negligence claim as well. So that's, hopefully I've answered your question. That's what it looks like to me.
Is it your position then that they're allowed to do that?
Who's allowed to do?
The housing authority can contract with builders that they know or should have known and turn a blind eye, and the building expenses lower cost, and if it ends up in construction defects, they can do so knowing they'll never have any accountability for that. They'll never be on the hook, so to speak.
Well, I think what you're getting at is some of the unfairness of governmental immunity, and the legislature has drawn these lines.
So yes, you're saying yes, that's the point of it, and that's how it works, and so yes.
Correct. I mean, but it's not like these plaintiffs or the HOA and their members were without a remedy. They had, you know, they had a construction defect right of action against the builders. We don't know what happened to it. Obviously, it's time barred now because of the statute of repose or statute of limitations, but they didn't pursue that avenue. Instead, they let it go and now are looking at the entities here to give them the remedy. And that's the problem, is governmental immunity steps in and says that's not one of the waived areas. That's not one of the areas that we believe that, you know, that should be subject to, you know, liability limitations.
And when you said that they're now looking for a remedy, do you believe that the remedy they're seeking is to turn a profit?
No, I'm not saying that. It's compensatory. They want their property damage alleviated and remedied.
Isn't there another source of duty they're arguing, and that is the statutory duty to either provide affordable housing through the multi-jurisdictional statute, or to provide a duty to provide safe and sanitary dwelling accommodations through the city statute, and the shall manage and operate these facilities through the county statutes? Aren't they saying, well, those duties, even apart from fraudulent concealment, it's those duties, and those are not tort duties?
That is their argument.
And
we
your
take
response?
issue. Yeah, we take issue with the first level is they're not duties, that they've listed powers, and the trial court, Judge Norton, saw that right away and said, look at these things that are being pointed to here. Whichever one you want to look at, the multi-jurisdictional housing authority statute, the city housing authority statute, or the county housing authority statute, the responsibility to provide safe and sanitary housing, all is in the powers. That's the ultimate goal, but the entities can assert powers, many different kinds of powers.
And those powers are in furtherance of the ultimate goal,
Of course.
which is,
To provide affordable housing. We don't run away from that, but they're not mandatory duties. And you know, we said it in our brief. There's, you know, the legal authorities that say that powers are not duties, And it's important because housing authorities get to exercise a whole panoply of powers here. They can decide to get into, for example, they can be a landlord, right? And if they want to be a landlord, at least for cities and counties, there is a power, there's a duty there that says you have to, if you're going to be a landlord, you better not charge rents that are going to be excessive. And you have to provide, in those cases, safe and nice units to live in. So the legislature has figured out when they want to impose a mandatory duty upon a housing authority.
What about 294229, which says it authorize and impose a duty on the authority to provide safe and sanitary dwelling accommodations? That's a duty, it's a language of a duty, not just a power.
Right, but that's in the city housing authority
right.
statute, which by definition doesn't apply to the county housing authority, the multi-jurisdictional housing authority statute.
Wasn't the city part of the intergovernmental agreement?
At one time, but the city's housing authority was dissolved at the time of the multi-jurisdictional, the creation of the multi-jurisdictional housing authority. And there's no similar incorporation clause in the multi-jurisdictional housing authority that are present in some of the other ones. So you can't.
Can you rid yourself of a duty just by passing it on to someone else?
Well, yes, because the duty by law follows the type of entity that is being created here. And so by sunsetting the city housing authority and the county housing authority, now you have a multi-jurisdictional housing authority, and it's subject to its own set of responsibilities and duties. And so that's why, yes, the answer is yes, you can, because, it flows from the legislative scheme in this case.
Under your theory, the multi-jurisdictional authority can know that these things are defective. I mean, they're just a rotten piece of work. Sell it to somebody, and the next day it collapses. And so the new owner comes to you and says, hey, you sold me a piece of junk. Nope, governmental authority, governmental immunity, you can't, I'm not liable. That's your theory, right?
Well, in a sense, I think it's missing one component in that the authority doesn't own these units and doesn't actually sell them. I mean, they're sold from, one owner to another, and just like any other real estate transaction, that allows for due diligence to happen between,
Well,
a
somebody has to
purchaser.
be the original owner.
Sure, but it was never the housing authority. It was private developer sold it to the first generation of unit owners, and then it got passed down all the way through. And there's, and everyone had due diligence opportunities on this building as it got sold.
So the
right on
housing
through.
authority never had any ownership interest in these properties.
Correct. With a couple small exceptions, I believe the housing authority does have the ability on occasion to foreclose and take and buy out somebody itself. I don't know if they've done it in these particular units. That's not in the record. I'm not sure about the history of that. There's one exception there. I'm just not sure about how active APSHA has been with respect to ownership in these particular units. It manages a great deal of projects within the Roaring Fork Valley. I just don't know about this particular one. But by and large, these things are just, APSHA is not, they're involved in kind of helping close these things and advertising them to qualified people, but they're not an active, they don't own one of the buildings, they never have. Those
So
kinds of
without
things.
owning any of the buildings and without having any duties or responsibilities with regard to the habitability of those buildings, is it possible that it's, these private builders and developers, the buyers and sellers can use the APSHA as a way to circumvent sort of these responsibilities or these obligations that
No.
would otherwise exist?
No, I don't, the housing authority laws don't grant them any kind of immunity. Them being the builders, any kind of immunity. No, I mean, they are just, the record shows that APSHA was involved in suggesting that this builder be involved, but they are not APSHA employees, they're not public employees, they're private entities. And private contractors with public entities under I can't tell you the case, but it's been pretty well established that the Immunity Act doesn't apply to contractors of public entities. So they're
Can I ask
subject.
you a different question? Excuse me, are you,
I am, thank you.
okay. Can we go to the rescission claim? The
Absolutely.
court apparently allowed that one to stand. And as I understand the rescission claim, they're not asking for to get the property repaired or anything like that. They just want to be able to sell their property at a fair price, and they can't because of these deed restrictions.
Right, right. And it would effectively, remove the affordability of these units if they had unlimited, if they got the resale price restriction lifted.
Well, why shouldn't they at least be able to recoup their cost of repair?
Well, on a legal level, I don't think there's any difference between the rescission claim and the other claims because they're all kind of rooted in the same facts. It'd be different if the rescission claim was a standalone theory that didn't depend upon anything the APSHA did. But it's not. It's just an alternative remedy for the same kinds of claims that have already been dismissed by the court.
But they're not asking for any repair from the defendants.
Yes, I get it.
They're just saying, I want to go sell it to some other buyer.
Right. It's an equitable remedy. It's, one would think, it doesn't look like a tort, but, our precedent in the CJA has said it applies no matter what the form of relief, and it applies to purely equitable remedies if they're rooted in tort.
It applies to purely equitable remedies, no money sought, anything like that.
Correct.
What was the case on that one?
The Robinson case, Robinson versus the
Right, state
lottery, yeah. Ms. Robinson had a rescission claim because she wanted her, the lottery ticket agreement rescinded and her money back.
And the money back.
Yeah.
And the money back. Do they want any money back for the rescission agreement?
No, they don't, but it's the equivalent of it. But because if you take off the restrictions, then all of a sudden, then they can sell it at any price, and they've gotten a unit. The members of this HOA have gotten a unit under a restrained price with the benefit of those retail price restrictions. And what they want to do is take it off at the back end, and they will, they will reap a profit far greater than what anyone else could. And that's a big problem with the rescission aspects of the
Well,
case.
if they're just seeking their repair money back, they're not really asking for a profit, are they?
Well, I don't know. I imagine if they don't want any resale price restrictions, they're gonna, the unit owners are gonna sell it for what the market will bear. I mean, part of the problem that I see with getting into this area is, the problem with their claims is it asks, the court to now step in and make decisions for APSHA and for these defendants in terms of how they manage their projects, how they, especially with respect to the funding issue, how they manage their budgets. And we're talking about core governmental functions that the trial court observed are the kinds of things that courts can't get into. She cited the Cornerstone versus the City of Wheat Ridge Housing Authority. I might have switched that. That's a real problem for the
Counselor, your
court.
time has expired.
Okay.
Thank you.
We ask that this court affirm the trial court's dismissal and reverse the one dismissal or the refusal to dismiss the rescission claim. Thank you.
Your Honors, I'd like to make 3 points on rebuttal. First, as to the nature of our requested relief, it is not compensatory with respect to the requested financing of the repairs because there is no directly proportional relationship between the cost of the repairs and the value of the units. Secondly, city and county authorities are established at the public's behest. 25 members of a polity get together, sign a petition, and can demonstrate that there is a need for a housing authority in their locality. That government, the local government, must establish a housing authority. And that housing authority is bound by the duties in the city or county housing statute. Surely the legislature did not intend to create a loophole for these polities to escape their duties by reforming as a multi-jurisdictional entity. And lastly, I'd just like to point out the authority does sell the units. It determines the price, it determines the buyers, it determines the condition the units must be in. It acts as the broker for both the seller and the buyer, and it collects a commission. It is simply not true that the housing authority takes a back seat with regard to anything to do with Centennial. They are actively involved in all of the financial aspects of life at Centennial.
How can the authority sell the unit if they're not the owner?
What I meant is that it facilitates the sale and it determines the price ultimately. The authority has set forth certain criteria that the unit has to meet in terms of its condition before it can be resold, and the authority can step in and say, hey, this unit isn't saleable as it is. I'm going to require you to put money in escrow for these repairs to happen. Alternatively, your sale price is going to drop. So really effectively, the authority is determining the value of the units. It's determining exactly what people get in terms of a return on their investment. In sum, Your Honors, we would ask that this court reverse the district court's dismissal of our mandamus and declaratory judgment claims and affirm the district court's ruling with respect to the rescission claim. Thank you.
Thank you, counsel, for your excellent arguments. The case will stand submitted, opinion will issue in due course. That concludes the business of the court for the day. The court will stand in recess, subject to call, and the bailiff will so announce.